Good afternoon, everyone. This is Chris Gantt-Sorenson with Haynsworth, Sinkler Boyd Law Firm, and I'm excited to talk to you about the changes that came about with the EEOC's 2024 guidance on harassment and discrimination. We have a special guest speaker at the end who can give us all some tips on investigations as takeaways. And looking forward to talking to you. So let's go ahead and get started. As always, next slide. Go ahead and pop in any questions that you have in chat or in Q&A, and Keely or Raven will monitor and make sure that I'm answering your questions if I'm getting going too fast and not seeing them. Any questions that we don't answer, I'll definitely follow up afterwards to the extent I'm able. So there's a ton of information to cover in this PowerPoint, and there's no way to, I'm going to be honest with you, this guidance is so long and it's replete with examples. And so there's no way for me to actually go thoroughly through it. It took me 3.5 or 4 hours when I was reviewing the guidance again for the purpose of writing this PowerPoint, and I realized I can't have all these slides. So what I will say though is the EEOC has given so many examples of how its investigations are going to go into these charges of discriminations going forward, that those are great opportunities for you to not only review them because a lot of the questions that you might have about what you're going to do about a specific situation is answered in those examples. And it's also good training. It's good training for other human resource professionals that report to you. And it's good training to use with your managers, these examples. So I encourage everybody to check out the guidance. I have it linked at the end of this presentation. So it's been, the 1999 was the last guidance that the EEOC issued. And this replaces all of it. Can you pop back, Raven, to the, thank you. The thing I want to point out that's the most important about this guidance is that when the EEOC investigates charges of discrimination that are filed with its agency and or their lawyers decide they're going to bring suit, this is the guidance that's going to be followed. In other words, a lot of folks say, well, it's guidance. Do I have to follow it? Well, the EEOC is charged with determining whether or not an employer has committed a violation of Title VII and ADA and Pregnancy Workers Fairness Act, and a few others. So yes, because the EEOC has the ability to adjudicate and fine and litigate against employers. So we always pattern our advice on this guidance. Okay, thanks, Raven. Next slide. So what's changed? What's new? Next slide. So first of all, the EEOC clarifies, and this will help all of you out that are, all of your employees come to you and they all think harassment means tension in the workplace. And they don't really understand the distinction, many of them don't, between harassing conduct that's illegal and just tension in the workplace or somebody getting on their nerves. So the EEOC in its guidance specifically clarifies that the only type of harassment that the EEOC covers is as it pertains to protected classes as defined under the federal law. And even some HR folks, some employers get this confused, not just the employees. Not all harassment conduct violates the law, and it must be evaluated on a case-by-case basis. And harassing conduct can be independently actionable as discrimination. So someone who is harassed may also have a discrimination claim. And the example here would be a woman who's subjected to offensive comments about her pregnancy, her lactation, her nursing at work, and then is demoted, or in addition to being harassed, there's some change in the terms and conditions of her employment, or she's denied some opportunity. That's an example of it. Next slide. Illegal harassment. So the EEOC specifically defines what the illegal harassment is. Number one, the workplace harassment must be based on a protected characteristic. And then number two, it must affect a term and condition or privilege of employment. Two factors to show it affects term and condition of privilege or of employment: adverse employment action or change in the terms and conditions by creating a hostile work environment. So the EEOC specifically says that harassment in the workplace illegal harassment in its guidance does not apply to run-of-the-mill boorish, juvenile, or annoying behavior. Now, I'm going to make a distinction here that in this situation, there's a distinction between hostile work environment and what's harassment and what would be discrimination, right? Hostile work environment would be where someone's subjected to offensive comments, jokes, leers that are on the basis of their protected characteristic. You do not have to have an affectation of a term, condition, or privilege employment for it to be hostile work environment. You do have to have it for harassment to turn into discrimination. Next slide. So this was the most interesting aspect of the EEOC's guidance to me. Historically, if you remember, there was a different way to determine whether or not hostile work environment was actually hostile. The EEOC has removed some of the confusion around that, and now there is a requirement that the harassment be unwelcome with both an objective and subjective component. So the objectively hostile analysis is, was the conduct sufficiently severe or pervasive to create a hostile work environment from the perspective of a reasonable person? So would a reasonable person be offended by the conduct? And this is going to be evaluated by expectations, the relationships, the specific work environment, and surrounding circumstances. And then subjectively hostile. Did the victim of the conduct actually perceive it as abusive or find it hostile? So, if it would have otherwise been considered objectively hostile, the victim of it must have perceived that it was also hostile to the victim. Used to be, there was only the objective criteria, and there was the analysis that hostile work environment was harassment that was unwelcome. And that is often where the confusion came into play. So these two criteria for determining what is a hostile work environment, I think, gives employers some peace of mind because it offers more certainty in the analysis. What is curious to me is, what will we do if we know some comments and behavior is clearly hostile under the definition of what we've known all of our lives to consider illegal workplace harassment, and the employee that's overheard it does not believe, was not offended? And I think that's going to be on a case-by-case basis. I think there's some things that are just going to be so clear to the employer that they amount to hostile work environment and harassment, whether the employee's offended or not, that they're going to have to address it. So I think employers have to keep this in mind and not think that just because the employee that was the victim or the purported victim of the conduct did not find it hostile, that it might otherwise, that it's not otherwise something excuse me, that the employer needs to address. Excuse me. Oh. All right, next slide. Y'all forgive me. I've been talking a lot lately. Who am I kidding? I've been talking a lot always. All right, so when is it harassment? A single incident of harassment does not usually result in a hostile work environment, but the EEOC gives specific examples of where it has. And there's been case law through the years on this point that all of us have used to advise employers on, but now the EEOC has pulled it all together specifically into this guidance and given a lot more instruction. And I think, again, this is going to give employers more certainty. The items listed here are considered a single incident that will automatically create a hostile work environment. And that's going to be whether it was subjectively hostile or not. This is just open and shut. This is a hostile work environment. It's going to have to be dealt with. Sexual assault, touching, physical violence, threat of violence, display of hate symbols, use of denigrating animal imagery, threat to deny job benefits, use of the N-word by the supervisor in presence of a Black subordinate. Specific categories that the EEOC will automatically find was a hostile work environment. Also, I think employers still get confused about this, but conduct outside of the workplace can be harassment. This can be on social media. This can be away from home work travel. This can be in the grocery store. If it's in between two employees and it would violate your harassment and discrimination policy inside the workplace, it's violating it if it occurs outside the workplace. Conduct that occurs in a non-work related context may also be harassment. And the example the EEOC gave there would be a Black employee who's subject to racial slurs by white coworkers on the street or on social media and otherwise has nothing to do with work. The other thing that's important is that conduct does not have to be directed to the complainant. So if there is an employee who overhears the conduct or sees the conduct, they may also have an harassment claim. This is in line with our jurisdiction's case law, the District Court of South Carolina, as well as the Fourth Circuit Court of Appeals. So this again is pulling in what is the general understanding under the case law and making it clear in the EEOC guidance. Next slide. Systemic harassment. So this is a new area that the EEOC covered in their guidance, and it is referring to in the workplace conduct that's harassing that may apply to all employees of a particular group. And so this is going to require employers to consider harassment not only in the context of individuals, but also whether or not there is systemic harassment. The examples would be that the EEOC gave. Black employees working on a particular shift were subjected to a widespread race-based harassment on the shift, or a group of employees with intellectual disabilities were physically abused, financially exploited, or subjected to verbal abuse. Also, there can be a pattern or practice of harassment as it applies to an employer's standard operating procedure, such as denial of medical care, threats of deportation, limiting outside contact with the world was considered evidence of national origin harassment. Next slide. Somebody just asked if you're going to get the slides. You absolutely are. Causation. That is another requirement and another part of the analysis of whether harassment, illegal harassment, or discrimination has occurred. So the evidence has to show that the individual was harassed because of a protected characteristic. Now, this is going to be whether explicit or implicit, or whether perceived, right? So if we think about we're harassing someone on the color of their skin, you know, let's say this is someone who looks Asian, right? But they're actually American. So that can also be considered harassment. Facially discriminatory conduct based on protected characteristic, stereotyping on social or cultural expectations, whether it's positive, neutral, or negative. So that's interesting. Positive, neutral, or obviously negative. Conduct must be evaluated within the context in which it arises. So example that the EEOC gave is the use of boy when referring to a Black man, or you people or monkey imagery in regards to Black employees. Comparative analysis. And by the way, I want to speak to that, not just in regards to Black employees. If any of this is going on at the workplace at all by any employee, and it's not directed towards other employees, this is going to be illegal harassment. It's going to have to be dealt with. Comparative analysis. So everybody, I think, understands that when we get into discrimination, sometimes an employee needs to prove as an element of their claim, if they're before the EEOC or in court, that they were treated differently than people who were outside of their protected class, and that's called a comparator. So, for example, a most recent charge I read was an employee who contended that a white employee who reported a charge being racially harassed, a white employee that reported being sexually harassed by an employee was dealt with differently than the Black employee who reported sexual harassment by the same offender. So that's a comparator analysis. Or another comparator analysis would be any sort of allegation that an employee contends unequal pay or unfair pay, where that employee was not given the same pay on the basis of their comparators who are outside of their protected class, what they're earning, or someone was not promoted, or someone was terminated in situations where other people outside of their protected class were not terminated or were promoted. So that's what they mean by comparator. Next slide. So severity of conduct is also required. Important thing to remember and train your managers is that when managers are engaging in this conduct, this is considered less severity is required in order to prove harassment, and that the severity lessens as we go up the hierarchy. So the president or the CEO, the executives of the company are held to a much greater standard, and this is true of all managers, but it's on a sliding scale depending on how high the hierarchy. the more direct the harassment is, the more likely it meets the severity requirement that the EEOC has outlined as important. And as I mentioned before, conduct not specifically directed at the complainant can be considered harassing, even though it's considered less severe. I mentioned this too, in the presence of others, such as the complainant's peers, subordinates, or clients, harassment is going to be considered harassment just by overhearing it, even if it's not directed at the victim. Next slide. So let's talk about the protected classes and the specific advice and comments that have come from the EEOC in regards to those. And again, I had to hit the highlights here. There are more, but I thought I'm touching on the ones that are the most significant. I would encourage you to look through the actual guidance yourself. So here are the covered bases that are listed by the EEOC as those that fall under Title VII. Race, color, national origin, religion, sex, age, disability, genetic information, retaliation. Sex, as you know, includes gender identity, gender, sexual, sex orientation. It includes pregnancy. It includes anything that has to do with anything with sex. The LGBTQIA plus community, lactation, every single thing that would have to do with sex. Next slide. All right, so race. EEOC specifically identified as harassing conduct, comments, judgments, or stereotypes about a particular race, traits or characteristics such as hair, cultural dress, accents, manner of speech, personality, emotion, expression, physical characteristics. Emotion. This is a classic example of what happens with people of color, specifically Black or women, specifically also intersectional situations where you have either of those, Black or of color and female and or disability, right? So these types of analyses often by an offender are subconscious, which means that an employer, specifically the HR personnel, is going to have to keep a close eye on that. I don't think it has changed. The statistic in the EEOC's 2016 report was that 3 out of 4 people did not report harassment. I don't really think, in my own anecdotal belief, and the fact, in my practice area, that it's changed much that people report things. I think people still are reluctant to report harassment at work. So this is, in my opinion, things that therefore require human resources to keep a close policing on any sort of conduct, because I will say that this guidance, while it gives certainty in some areas to the employer, there are other areas that I think it creates more room for confusion, more room for gray area, and when you might need to act. So at a minimum, acting with additional training or mentioning things to people can only help you legally, especially if you make a documentation about it. So race and color that intersect based on skin pigmentation is another area that the EEOC has mentioned. And then an example that they provided of that was the supervisor harasses Black employees who have darker complexions, but not those with lighter complexions. So Stephanie or Selena just asked, what about reports of hostile work environment in which the person reporting did not hear anything? Nothing was said directly to them, but they feel they are treated differently and they were told by someone else about the comments about them. So interestingly enough, I actually have that in a case of mine. I have other facts, by the way, that make it, less of a standalone issue. But in this case, allegedly there were racist comments made about an employee to her supervisor that she did not overhear, but her supervisor came and told her them. There may be some argument that by repeating them, the supervisor has engaged in this conduct. But to the extent, my role is determining whether or not the employer has liability for illegal harassment on the basis of race as a result of this. My answer to your question, Selena, is going to be based on who the speaker was. Remember, there is a sliding scale of severity. And I think while maybe somebody that has a peer that has made this comment to someone else, they're all equal peer, and it gets shared with the other person. And depending on which protected class it is, because I do think comments in certain classes are considered more severe than others. So if it was about race, it's going to be more severe. If it's about religion, it may be less severe. Military status, it may be less severe. So I think it'll depend on, number one, who was the speaker? Was this a manager or higher level? What were the varying hierarchies of the folks involved? And number two, what was the context of it? What was specifically said? And then I think you are also looking at the circumstances around it. But I'm going to tell you this: if there are things that are being said among peers, and it could potentially implicate Title VII, folks, do training, have training, and have everybody sign for the training. And that is evidence that you are doing what you can to make sure that your policy is being followed. In addition, of course, to addressing issues that arise. So if something arises, you need to deal with it in a way that's proportionate to what's happening, and you need to document that you did it so that later you can prove you did. Good question, Selena. Thanks. Next slide. All right, national origin. So specifically in regards to national origin, the EEOC said this is based on the place of origin of the individual or the individual's ancestors. And it pertains to offensive comments and derogatory treatment on personality traits, physical characteristics, ethnic or cultural practices, religion, diet, non-English language, or accent. All right, so a good example would be someone that works in your office who doesn't eat meat, who's Indian, or who has a little bowl of the types of after dinner seeds, and they're delicious. But I'm sure I'm not saying the right word, to eat, to freshen the breath afterwards, and making comments about that. Those are things that could be harassment on the basis of national origin. And national origin and color intersect. Those two intersect. So you have, when you think about race, you have color, you have national origin. All three of those alone can amount to harassment depending on the situation, and they certainly can intersect. Next slide. All right, LGBTQ plus workers. The EEOC, this is where their most examples were. And I think that is because this is the first EEOC guidance that's come out after SCOTUS's 2020 opinion in Bostock, which said that sex includes sex orientation and gender identity and all aspects of LGBTQI+, and it shouldn't have anything to do in employment at all. Some of the examples that the EEOC, or some of the specifics that the EEOC said would amount to harassment and frankly discrimination, is denial of access to the bathroom of the person that they identify, the gender that they identify, refusing to recognize pronouns or misgendering, chiding, joking, or comments around stereotypes of their gender or gender identity and appearance, use of the bathroom or gender identity or pronouns. So I do recommend that the employers who are performing training for your managers and your employees, which you absolutely should do regularly, consider using some of the LGBTQ plus examples from the EEOC's guidance. This is an area that has caused a lot of consternation recently and frankly historically, and it needs to be dealt with, because regardless of whatever anybody's opinions are about this, in the workplace, it's illegal and therefore cannot be tolerated. Next slide. All right, so sex, and I mentioned this earlier. Here's the specific areas that were given examples. Gender or gender identity, some examples of things, comments, microaggressions that could be considered hostile work environment. Were you born a man? Are you transgender or transvestite in the pronouns? Or sexual orientation, who's the man in the marriage? If there's a child in the marriage, who's the dad? sexual comments on the basis of lesbian relationships. Pregnancy, childbirth, and related medical conditions also, as we indicated, fall under sex. So anything about lactation, contraception, abortion. You know, if you have folks that nurse in your offices and they're behind their office door, remember they have to be lockable per the ACA. But, you know, anybody knocking on the door or, you know, trying to look over and see who's in, or teasing, you know, any sort of teasing. Any sort of comments or harassment around absence before or after childbirth due to pregnancy, childbirth, conditions caused by or onset as a result of lactation, you know, any sort of denial of opportunities, any sort of decisions about employment on the basis of someone, you know, being, you know, having recently had a child, you know, continuing to nurse, those sorts of things. Next slide. Sex and gender. So this will include comments such as women who do not belong in management, men should be nurses, a bullying directed at one sex. Includes individual displays of sex or sexual remarks, conduct of a sexualized nature, such as an unwanted expression of sexual attraction, attention, demands, pressure. There can be same gender on gender harassment, sex harassment. This includes questions about sexual anatomy and sexual relationships. It includes assumptions or employment decisions about employees who are pregnant, lactating, or caregiving. So these were all specific examples covered by the EEOC and the guidance. Next slide. All right, so now specific to, yes.
Oh, sorry to interrupt. Before you move on to this topic, there was a question in the Q&A.
Okay, I see it from Gina. See
Yep.
it from Gina. I think, thank you, Keely. I think people, you know, get tired of me just going through all these slides. So that's great. Gina asks, regarding diet, what about comments based on ethnicity that are supported by scientific data? As an example, you should not eat that since high blood pressure is proven to be higher for African Americans than others. That is absolutely harassment. So Gina, that absolutely would be harassment. And that would probably be considered systemic harassment if that's a comment that's made generally. So that would have to be addressed. Those comments are just not appropriate in the workplace. They just absolutely are not. Great question. Okay, I think there's another one. Oh, Gina just said thank you. All right, and I'll check the chat box and then I'll continue to cover this. So I think an important thing would be to make the point that everybody in the workplace understands pregnancy and nursing does fall under what Title VII defines as sex. And so we have the Pregnancy Workers Fairness Act, the Pregnancy Non-Discrimination Act, the South Carolina Pregnancy Accommodations Act. You know, we have the PUMP Act, you know, for nursing, and prior to that, the state lactation support acts or nursing mother support acts. All of that exists. But in addition, it's important to understand that Title VII also includes this category under sex. And particularly intriguing in light of more recent Supreme Court opinions and political discussion is that the EEOC specifically says any sort of comments to any employee about contraceptive choices, abortions, decisions to have abortions or not have abortions would be considered illegal harassment. Also, this would include a need for or a request for an accommodation as it applies to harassment as a result of accommodation request pursuant to anything that would fall under pregnancy and nursing mothers or contraceptive choices, any of that. Now, I know that in our state, abortion is still illegal. But if that were to change, or frankly, any discussion with any employee about that, regardless of whether they're going out of state or not, should not be done. That should not be done. I know there's a lot of political discussion around that. Can employers penalize employees for going out of the state? Can healthcare plans intervene? I would say this is an area that needs to be tread very lightly on it. There really should be no discussion about contraception and abortions in the office. To the extent that the employer's healthcare plan covers certain contraceptive methods, there really should never be any discussion about that in the office. If there is any need to discuss what is and what is not covered, if you have a fully insured plan, I'd encourage that communication to be happening directly with the carrier. If you have a self-insured plan, but you have a third-party administrator that monitors it, again, let that conversation happen with them. And you, no one at the office, the HR or have you, be at all familiar with any of those discussions around those topics. No knowledge back to the HR about that. Next slide. So age. Negative perceptions about older workers, pressuring older employees into less technical jobs, encouraging older employees to retire or making comments that they will retire soon. Amazingly, this is something I still get asked a lot. This is something that people still say, well, we'd like to go ahead and encourage them to retire. And they think they're helping. And they really are. A lot of times the concern is genuine. Someone who is not performing and who they want to let go, thinking this will be an easier letdown. Absolutely not. It absolutely never can be mentioned to any employee about retirement. That just cannot. That is absolute grounds for an age discrimination or harassment claim. That is different when the employee comes and says, I would like to retire. I had a situation the other day where an employer was going to need to let somebody go because they weren't performing well. And their thinking was, we're going to eliminate the position. And of course, my answer always to that is if someone's being let go for performance and you tell them that you're eliminating their position, then you do potentially give them an age claim when you either fill the position or reassign their duties to someone younger. So first advice there is just be honest, tell them it's performance. And if you've documented the performance even better, that'd be fabulous. That's desirable. That's the best case scenario to defend yourself. But even if you haven't, please be honest and tell them this is about the performance. It's just not working out. And then if that employee says, well, could I be permitted to resign? Could I be permitted to retire instead of, being terminated? Always say yes. And if you are going to enter into a severance agreement with that employee, you note in the agreement, you don't call it a retirement agreement, you don't write retire anywhere except where in the section where you say employee's employment was going to end on the basis of performance, but the employee asked to retire instead, right? So you protect yourself and make sure that if there's ever anything in writing about that it was always something the employee brought up. All right, next slide. Religion. Just a reminder that there is a new standard applied to any accommodation request under religion. And now it is the same exact one that you apply for any disability accommodation. In other words, undue hardship at the level that is required for ADA, as opposed to prior it was de minimis, which is more than minimal. So now it's the same level as ADA. The EEOC said that it was important for employers to protect employees from religious harassment in addition to considering their religious accommodation request for a sincerely held belief. And they are not required to permit religious expressions that threaten to create a hostile work environment. The way that this guidance particularly was written is to suggest that religious expression at work was not going to outright be considered hostile by the EEOC. But when it got to the point that it threatened to create a hostile work environment, then it would be a problem. I think that's an interesting analysis. It's an interesting comment, because how do we know, right? And we think back to the objective and subjective hostile work environment standard. And here's where maybe welcome and unwelcome could come back in. So one thing where employees over lunch are sitting together and they're having discussions, and that's all part of their Bible study group that they do at lunch, that's probably going to be fine. But what are we going to do about someone who is during work hours talking about religion around other employees? That's something I still think we have to deal with. I think expression in that scenario can quickly cross the line. But this makes it sort of difficult. And it would be easier just to thwart all religious expression at work. But what we have learned in recent times, that while that might be easy, banning uncomfortable conversations or any comments or pretending like they don't exist is actually creating a chilled work environment. Can't win for losing. All right, next slide. Religion is broadly defined and includes lack of religion, atheism, or lack of religious belief. It pertains to comments about religious practices, about the religion, or the dress. So asking probing questions about an employee's faith, which someone might just be interested in learning more. But if this is considered offensive to the person hearing them, it could be considered a hostile work environment. This can also come into play when an accommodation is requested. You know, an employer has the right to ask the employee a little bit about the religion that the accommodation is based on and the religious practice. There are many employment lawyers who say, once you have determined that this is a religion, or, you know, that you don't get into whether or not the practices are going to be protected. But so that, I think that's an area where if this really comes into play, you might just want to get legal advice and counsel, because the EEOC does have some specific guidance on what a religion is, which is very broadly defined and to include all manner of things that you think are not a religion, whether it's sincerely held, and whether the practice that they're asking an accommodation for is a practice of that tenant, is that of that faith. So religious expression, and here it is again, does not necessarily create an objectively hostile work environment. So here was an example that the EEOC provided. An employee attempts to persuade another employee of the correctness of this employee's beliefs. It's not necessarily hostile unless the hearer objects and the employee continues discussion regardless of the objection. So this is a specific example that the EEOC is given, where it's requiring the employee who's listening to the expression have to say, hey, this is unwelcome. You know, and we have gotten away from requiring our employees who are reporting harassment to us to tell someone before they report it, hey, this is unwelcome. So I'm not sure what I think about this criteria, because I think it creates a situation that's ripe for uncertainty in whether or not something's going to be illegal or not. Again, I think training specifically on this topic and all of the topics that we're discussing helps inform employees what they can say, what they can object to, what their rights are to say, hey, you know, this, I'm not comfortable with this. And again, if you have an employee who is trying to persuade other employees about the correctness of their beliefs, I'm going to tend to err on the side of, we need to, at a minimum, counsel that employee, which we document and the employee signs, that they shouldn't be doing that. Next slide. Disability. Physical, mental, or developmental. Comments about how an individual speaks, looks, or moves. And remember, this is going to include positive and negative comments, all right? So positive comments, wow, it's so impressive what you do. Wow, I don't think I could do this. It's amazing. Those things could be considered harassment. These include requests for receipt of an accommodation, you know, inquiries about what is the disability. It's not clearly apparent to me. And it includes individuals that are regarded as disabled, whether they're not, they're disabled. If we are treating them like they're disabled, or they are regarded in the workplace as disabled, it will include them. All right. This also includes harassment or different treatment because of an individual that they are associated with that is disabled. This comes up a lot of times in the context of caregiving and also in healthcare plan expense. So a risk of retaliation if this person is a dependent. That is covered under the company plan. Next slide. Retaliation, everybody knows what that is. I'll just go over it again, that if someone engages in a protected activity, which means they make a complaint under Title VII for discrimination, harassment, or retaliation, or they make a complaint under safety, or they make a complaint under pay, any sort of thing like that is going to be protected. Even participating in an investigation or a hearing or proceeding under EEO, NLRB, any other agency. All of that is protected activity, and any action taken in result or in regards to that employee as a result of that would be illegal. Next slide. All right, so a couple of things about adequate prevention measures, and then we're going to slide to my friend Sharon Sellers, who is going to join us, as I indicated earlier, and talk about some quick tips on investigations.
Chris, there's two questions in Q&A on the religion basis. If you want to
Keely,
check out those before we move on.
Thank you. All right, so Annie asked, in your example of talking about religion on lunch, in the lunchroom, what if another employee is offended by it? Absolutely. If another employee is offended by it, then we need to talk to the employee who was having the conversation to, tell them it's fine for them to, read the Bible and have discussions with people that are not offended by it. But that if people are offended by it, we need to be careful about those communications. My example, and I'm sorry if I wasn't clear enough, would be we're at lunch, we're in the lunchroom, and we're having a discussion with the people that are at the table with us, and it's all welcome. All of us, this is our Bible study, and this is what we get together and we do together. We're not, we're not requiring anybody else to be present, and we're, not being so loud. We're being respectful, and that would, hopefully be true of any conversation during the lunchroom and the lunch break. So, but it is a good question that Annie asked, because we already did say that if someone overhears it and they're offended, that might be harassment. I think if that got reported, the employer would have to mention, hey, to the folks that are meeting and doing the study, hey, just keep, keep it down a little bit. But I think in a situation where someone was not actually, a participant in this discussion and the like, I don't know, you would have to evaluate the circumstances of it to decide whether or not this was going to be something that the speakers should be counseled or anything about that. Remember that the EEOC said circumstances around it are considered. There are some things that are obviously outright obvious hostile work environment, but I think we're thinking case by case basis and circumstances surrounding it. And, there's always people who complain about everything. So I think you're going to have to evaluate whether or not that is going to, in that situation, as it occurred then, amount to something that you need to address. So next question by Lisa. With regard to religious dress, what if the garment or garments might impose a safety risk? For example, a hijab in a bakery that uses mixers and sheeters where the garment can be sucked in and injure the employee. Absolutely. That is a bona fide job requirement, for safety. And an employer absolutely can prohibit any sort of dress that is going to risk the safety of any employee. Before it is prohibited, there has to be a determination of whether or not there is a way for the employee to continue to practice their, wear their religious garb as practice of their faith in a way that will not cause them injury. So a shortened hijab or one that only goes to here, those are discussions where we talk to the employee. This is an interactive process. Remember, this is the same process we use now with the ADA. We've got to document it. And so we're saying, hey, we've got to keep that. Well, this is a safety rule, and we can't have you being pulled in the machine. That's just a no. We got to protect you. And I know you want to wear your hijab, but is there a way that we can do this in a way that lets you wear this garment, but that does not pose any dangling or hanging down risk? Now, if you have this rule, presumably you also have it for long earrings or any sort of things that would apply to people outside of this religion. So that would apply more neutrally. In other words, that we could point to and say, this is a consistent policy, a safety policy we apply across the board. If there is not a way to do this and to honor the dress without risking safety, then you absolutely have to put safety in front of the other. There needs to be a discussion with the employee that's documented to that effect and explained. So by that, I mean, we're sitting down and having a discussion with the employee and somebody is taking notes and writing it down, and everything that's said is going into that file. And the employee signs and says, this is what we discussed. Then you've done what you can do. All right. So preventive measures, they remain the same. You've got to have an effective anti-harassment, non-discrimination policy. What I'm not seeing in these policies is that you've got to define harassment and discrimination. You've got to define what is prohibited. The policies have to be understood by the employees that the employer chooses to employ. So if this is employees who have English is not their primary language and you've hired them, then it's got to be translated. For those that are disabled or those that are illiterate, there's got to be ways that they can be trained on these policies. For literacy, maybe TTY or a hearing rendition of the policies. And that's going to be true of the handbook. They've got to have access to your white paper, your employee policies, in a way that they can understand them. State supervisors must report harassment when they are aware of it. So the policy, and I think most policies say that, supervisors are required to report the harassment. And that also should be part of the training. There should be more than one avenue to report harassment. Typically, you need to have 2 or more avenues to report harassment and include the contact information in the policy. You've got to outline what your complaint process is. And of course, you've got to have the anti-retaliation and confidentiality if you can guarantee it. I mean, if you can protect the confidentiality of the reporter in a statement that says in some situations you may not be able to. And you've got to be able to prove that it was distributed to the entire employee population. Next slide. The complaint process, it must be prompt. The EEOC specifically says it must be prompt. It must occur reasonably soon after the employee complains or the employer had notice. And promptness is, in fact, impacted by the nature and severity of the harassment. My advice is this really needs to be within 1 week. That's what I always prefer, at the most 2 weeks. The sooner, it just has to be quick. It shouldn't go on for a long time. It must be adequate, meaning, according to the EEOC, arrives at a reasonably fair estimate of the truth. There has to be corrective action that is reasonably calculated to prevent further offense, and it's proportionate to the seriousness of the offense. So sometimes that's just going to be outright termination. Sometimes that's going to be written warning. Sometimes it's going to be coaching. Adequate confidentiality and anti-retaliation during the complaint process means you're following up with the reporter and making sure that they're not experiencing any retaliation. And to the extent an employer is able to, they must, the EEOC says, they must protect the confidentiality of the harassment allegations, which I think is interesting because, you know, historically our position has always been we have to tell the employees we're not going to be able to do that. But the EEOC is specifically requiring that we must do that where we can. Next slide. Corrective action. Employers have a heightened responsibility to protect employees against abuse of power. So we're back to the hierarchy analysis. Authority granted to the harasser heightens employer responsibility. Employers must monitor situations to ensure harassment has stopped once it's been reported. An employee who has in good faith complained has no responsibility for prohibiting the harassment from occurring again. Employers are not required to impose discipline if it includes the harassment did not occur after a thorough investigation. The EEOC specifically says that. However, it's always a good idea to do training. All right, next slide. Hello? Next slide. Oh, effective training. Sorry, no, back. Everything froze for a second. Effective training must explain the anti-harassment policy and complaint process, show them where it is, talk to them about how to resolve the issues, talk to them about the confidentiality and anti-retaliation protections. You need to describe the prohibited conduct and provide examples. Provide information about employees' rights if they observe or become aware of or report conduct that they believe is prohibited. Cover that supervisors have to report it and how they need to manage it. I think you always need to have management training on this topic separate than employees training. And then you need to do this regularly. A lot of folks ask me what that means, you know, annually when we onboard. What if you mentioned it, you know, what if you covered a specific topic every employee meeting once a month? Think about how you can be bringing this topic up more regularly so that it's constantly on the employee's radar and the importance of it is conveyed. And you've got to tailor your workplace training to the workforce, making sure that it's easy to understand in a format they understand. Next slide. All right, implementation. Here's the thing. You can have a great policy in writing, you can have great training, but if you don't enforce it and make sure that you're using it to address harassment and make sure that you're doing what you can to prevent it and to remedy it and eliminate it, then it won't matter and you won't get the credit that you get under the law for having an effective policy, which is helpful because it permits you to bring in certain affirmative defenses for punitive damages, and at certain times can get a case dismissed if a complaint wasn't reported. So there is a legal reason to make sure that these policies are being enforced, which can help sell this and the importance of really implementing training. I mean, a discipline where it should be appropriate discipline when you have decision makers who are reluctant to do so for producers. Next slide. Employer liability, real quickly, because I want us to get to Sharon. Next slide. So here are the liability standards for supervisory employees. In a situation where the owner is one person, that person's going to be an alter ego of the company is liable for the owner's actions. If the person is the alter ego of the company and that they're the face of the company, let's say a CEO or president, whether they're the owner or not, the organization will be liable for that person's actions. So other cases, the employer will be liable for a supervisor's conduct if the supervisor observed it and took no action. If the supervisor is a harasser and no intangible action was taken against the victim. If the harasser is a supervisor and the employer failed to act reasonably to prevent the harassment or take action to correct it. So to just repeat it, if you're the owner or you're the alter ego of the company, the harassment, the employer is going to automatically be liable for it. If the harasser is a supervisor and the supervisor took employment action, tangible employment action against the victim, that's going to be where an employer is automatically liable for it. What that means is if there are tangible employment actions, that's any adverse employment action, any change of conditions, any promotion, demotion, anything, HR is going to have to be weighing in and evaluating it before it happens. Because in this situation, if the harasser was the supervisor and they were the ones who made the employment decision, then the employer is automatically liable. Supervisor witnesses harassment and fails to report it. Harasser is a supervisor and the employer failed to act reasonably to prevent the harassment. All right, next slide. Non-supervisory employees, there still is liability for them as well if the employer unreasonably failed to prevent the harassment. And sorry about that, that's a typo. Unreasonably failed to prevent the harassment or failed to take reasonable correction action in response to the harassment. So it gets reported and the employer doesn't take the steps they need to, i.e. investigate and discipline, or do the things that they need to do to prevent the harassment. All right, next slide. Oh, one thing I wanted to say, no need to go back, but keep in mind too that when you have temporary staffing agencies or you use temporary employees or you have somebody else supply employees for your company, that you will be liable as a joint employer for any actions that are done by the staffing agency, or that apply to the staffing agency employees. The affirmative defense I mentioned, if you have a good policy and you apply it and you adhere to it, you get an affirmative defense that helps you in court. Next slide. You can see I'm trying to slide to get to Sharon. Delay. An employee who waits too late to report the conduct. If the employee complains at the same time the employee is departing employment, an employer is not going to be held liable for not investigating and dealing with the harassment. The delay may be reasonable, however, if the employer has created obstacles to filing the complaint, including undue expense by the employee to file. I don't like it when employers say, well, we need you to write it down before you look into it. I think that runs the risk of being in violation. If the people who are the avenues of report aren't available, or if they're not receptive to it. So if the employee has a reasonable belief the complaint process will be ineffective, the employee doesn't have to report either. That would be situations where the employee has seen reports made and nothing happened. There were no corrective actions. Or if the employee had observed others being retaliated against and was concerned and it was reasonable that they might get retaliated against, then their delay in reporting it will not exonerate the employer. Next slide. Finally, an employer is on notice if they have actual notice, meaning someone has reported it to the employer or any of the supervisors, any supervisor level is a report to the employer, or they knew or should have known. They should have known that it was happening. Next slide. Here are the resources. And now let me tell you real quickly about Sharon, who's been so patient. Sharon is someone that I have recommended as a presenter, as well as, and there's Sharon, and as well as an investigator to a number of my clients over the years. And I want to click to her slides. Sharon's going to talk to us a little bit about investigations and what she can share. But she's someone that when we need an investigator to come in, this is who I'm recommending. Um, I will tell you, she taught human resource courses for 12 years at Trident Tech. She is actually currently on the South Carolina Human Affairs Commission. She was appointed by Governor McMaster in 2022. She, in 2016, was the South Carolina Human Resource Professional of the Year by the Chamber of Commerce. She's spoken to the U.S. House of Representatives about updating their policies on workplace investigations and harassments. And she spoke before the EEOC Commission in Washington regarding retaliation in the workplace causes, remedies, and strategies for prevention. We are lucky that Sharon is a South Carolina resident and has made all of these great strides and achievements for human resources. And I am lucky to have her to recommend to clients. So Sharon, sorry for the lack of
Oh,
time, but I
that's
don't worry
fine.
about you.
Thanks so much. Yeah. And I'll make this quick. And Chris and I had recently worked on something, and we talked a bit about different things we could do. And one thing is how important a good interview is when you are trying to get all the information together for an investigation. So an investigation has occurred. Now what? And I did my first one about 30 years ago. I was looking, my first one was in 1988. And I'd love to say I did everything right and always have, but no. It's been the school of hard knocks. And so these are like my top 5 suggestions on what happens during for a great workplace interview when you are having that investigation. And step 1, of course, is preparation. So the person may have written down their complaint, or maybe they came to HR and then HR made a list of notes, but somehow you have a list of what happened. And usually my first step, if at all possible, is to try to talk to that complaining party. But don't just walk in there and ad lib. It's very important to go through as many different questions in advance to think of what do you need to know, and have that. I actually have mine typed out and a space below it, and I handwrite notes on what the responses are. So that's number 1, is make sure you do as much preparation as you can before you start that very first interview. Okay, next slide. All right, take good notes. I handwrite mine. I do not record these interviews. A lot of times I feel like people don't speak as openly if they feel like they're being recorded, although I make it public. I actually have a little thing I read to begin with that, I'm going to make my notes. It's not going to be word for word, but I'm going to get the general idea. And I'm also going to send these back to you when I'm finished to make sure that I did get what you were talking about correct. So I don't make a recording of it. A lot of it has to do with storage. I just don't want to deal with a whole bunch of flash drives running around. But also I make the notes as clearly as I can. And my big thing is to make sure I write them clear enough for me to read my own handwriting once the interview is over. All right, let's go to number 3. One thing, I may have all of these wonderful questions, but there may be something that later on we find out, and I go back to the person and say, why didn't you tell me about this? And they'll say, well, you didn't exactly ask the question in the right way. So because of the errors, I've actually started asking a question. Is there anything you'd like to add where maybe I didn't ask the question in the right way? And that way, that kind of gives them an open forum. Whereas there's something they've been wanting to tell me, they can go ahead and tell me. And I kind of hold them to it later on because of this question. Remember, I asked and you didn't tell me about that. Number 4. What do you think should be the outcome of the investigation? I like to ask the complaining party about that because I have sometimes we run into a situation where the person just they just want an apology. They just want the situation stopped. Obviously, if they say, I want that person terminated, that's not their call. But sometimes it's very helpful to find out what the complaining party is looking for at the end of the investigation. And number 5, the very last one, I send the interviewees my interview notes. I type them all up and send them off to each interviewee and say, this is my notes. is this correct? Feel free to pencil in the changes before you sign off. And I know that helps out Chris in the end, because if we end up where someone says, I didn't say that, or I didn't do that, we can pull out that and say, you said it, you actually looked at the notes and signed off on it. So we were under the impression this was the correct information. So that's real quick, a quick run through, not all of the things for an interview, but what I would consider my top 5 suggestions for a great place to interview. And thanks so much, Chris, for the opportunity.
See how amazing? She's just amazing. Anyway, thank you, Sharon. I felt like all of that would be helpful. It's easy enough guidance to follow, and absolutely the way the training should be done. And amazingly, she managed to do it and still get us done at 1. What can I say? I don't have that power. So thank you all for coming. We will be having a presentation same time next month, 4th Thursday. Haven't quite decided on what, because there's actually so much. So look for our blog about it and make sure you sign up. As always, when Keely emails you the slides and the recording, if you could just please let her know if there's anything that you want to hear about, because if there is, then we want to talk about it. Have a great rest of your day.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.